Okay, so yesterday, I'm Greg with the Ashcraft firm, and yesterday I talked to you about estate planning and adoption and about how the law treats adopted children the same as biological children, at least here in California. I can't speak for the whole country, but here in California, that's the way the law works. And so I do want to talk to you about considering a trust for your adopted child. If you're adopting somebody who's under the age of 18, they're a minor, that you probably want terms in there that will stage distributions. You probably, the year they turn 18, you don't want them to receive all of their inheritance. You want to make sure that they are old enough to actually deal with large sums of money, or relatively large sums of money. It'll be large sums of money to them. And the way to do that is by establishing a trust. It's much more affordable for your child rather than having the courts oversee how their funds are distributed and things like that. And the courts, they really want to default to distribute everything as quickly as possible when somebody turns of age. But that's usually not the best for the actual child at question here. So if you create a trust, you can create terms that protect the property from themselves and from a lot of other things that can happen to them during their lifetime, like divorce or a lawsuit, or if they file bankruptcy at an early age because they're learning how to deal with their finances. You can protect them from those things by creating a trust. But the biggest thing that you want to create trust for an 18-year-old is usually protecting them from themselves. So you can put whoever you want in charge of the finances up until whatever age you choose. So if you don't think that they'll be ready until they're 35, then you can have a trustee in charge of their finances until they're 35. If you think it's 25, if you think it's 18, you can choose that. But there's also considerations if you have special considerations if you have a special needs child that you've adopted. If that's the case, you probably want to create a special needs trust. And a special needs trust, the purpose of that is that beneficiary who you've designated to receive funds from that special needs trust can receive government assistance and receive distributions from the trust at the same time. So some people call it a supplemental needs trust, and that's because whatever the government's giving them, it can be supplemented with what you leave them in a trust. So that's a really good way to protect for special needs beneficiaries too. My name is Greg, and I'm with the Ashcraft firm. Thank you so much.